talk about basic estate planning. And so it is basic, but there's some details here. Maybe some of the things that you want to watch for, some things that hopefully will help you in estate planning. A lot of times, I think what happens, we look at estate planning and people, they get the impression that what happens, it's very complicated. And it doesn't have to be. So I think for most of us these days, given the tax protections that we have, and we'll talk about those, but given those tax protections, estate planning can become pretty basic, pretty straightforward. It's just one of those things where you have to take the time, sit down, think about it, and move on from there. So what we get to is this. First of all, making a will. Many times what happens, people say, well, you've got to have a will. And a will is a good thing. A will does things that do help you, but you may be surprised to find that actually not everybody benefits from a will. There are certain situations under the law where the will does really no more than what the law already provides, and we'll talk about some of those situations. So don't get me wrong, I'm not downplaying a will, but I know a lot of attorneys say, well, everybody needs to have one, and that's not necessarily the case. I do have clients, we sit down, we talk, and I tell them this. I say, listen, here's the deal. I can make a will for you, but I don't think I'm going to give you any benefit for the price that you're going to pay or the expense that you're going to incur. And so it's important, again, to get that big picture of what estate planning is about. And so we talk about coordinating all aspects of the plan. The property that you own. Now, by property, it could be a house, it could be land, it could be a timeshare somewhere. Remember, that's property. If you've got a timeshare, that, in fact, is property. Your vehicles, your furniture, all those kinds of things, your boats, your toys, so to speak. Retirement and insurance, how are those set up? Big things there we're going to find are what? It's going to be primarily about beneficiary designations. Retirement and insurance can be handled quite readily by beneficiary designations, and investments can actually be done the same way. If you put designations on your accounts as to where you want money to go, stocks and bonds to go, investments to go, many times that takes care of the issue with which you're going to deal. And we're going to talk about that as we go through today's program. So first of all, what are some planning issues? Well, first of all, taxes. We're going to find that taxes in estate planning itself are not the problem that they were in the past. Many times people will say, well, gosh, my kids are going to have to pay all these taxes in the event that we die. You're going to find out that's very, very, very rare these days. If you're a resident of North Dakota, based on the current tax situation, estate tax is almost non-existent. Asset ownership, very big item. Very big item. A lot of your planning can be done just in the way that you own assets. For example, if you're a married couple and one of you maybe inherited some property from your parents, maybe a piece of land and you've got it just in your name. Well, the way that you own that land in your own name controls how things are handled upon your death. And we're going to talk about that. If it's owned in your own name, you're going to go through a probate process. If you, for example, put it into a joint name with your spouse, there you're going to avoid probate and you've got some planning issues to go. Wills. As I said, wills are still important. I don't mean to discount them, but I think, quite frankly, in the typical situation, let's say the traditional family, for example, and that traditional family with some kids, in many instances, the will may become one of the lesser important issues in that estate plan unless certain things happen, and we'll talk about that. If there are minor children, for example, then it does become an issue. Trusts. Many times, many times, I will have clients come in and say, I want to have a trust in order to avoid probate. Well, in North Dakota, I will tell you that in my opinion, been doing this a long time, but in my opinion, a will and proper designation of assets with beneficiaries can do everything that a trust can do. Now, that doesn't mean that you can't have a trust. I have clients who say, I want a trust. and I'm willing to do it. And we'll talk about how those work. If I have clients that have property out of state, these days, especially when the market went down in Arizona, a lot of people went down and purchased houses in Arizona when the market was down at its lowest. And you know what? If you own property in Arizona, you own property in Arkansas, Florida, California, Nevada, some of those places, many instances, that is a time to have a trust. And the reason, and we can talk about that more if you desire, the reason is if I own property in Arizona and I die and my name is on that land down there or that house down there, I'm now going to have to open a probate not only in North Dakota, but also down in Arizona. The trust is the way that we get around that. And so I will find that in many instances, if not most instances, where I have clients who own property out of state, it could be Minnesota. You could have an interest in a cabin in Minnesota. Maybe you have some property down in South Dakota, down in the Black Hills. We can use a trust in those instances to avoid the probate in those other states. Business transition, I'm not going to spend a lot of time on it, but I think it's worth talking about, because many times what I find is when I talk business, I'm including farm families, ranch families, those situations where the question is you could be involved or somebody in your family is involved in a business. And the question is what's going to happen when one of the owners, one of the participants in that business or in that farm or in that ranch dies? Is there a plan for what is going to happen? And we're going to find if there isn't a plan, that can cause issues. In fact, that can cause big issues. Power of attorney, an important item. Quite frankly, I think in most cases, or I take that, but in many cases, the power of attorney is every bit as important as, if not more important than the will. Because what the power of attorney does, it gives somebody the ability to make decisions and sign documents on your behalf while you're alive, and most importantly, if you become disabled. And again, we will talk in more detail. Healthcare directive, finally, that's what we often talk in terms of the living will, the living instructions. What happens if I can't talk to my doctor and I'm dying? Have I made provisions so that my family and my doctors know what my wishes are? Do they keep me alive on the machines forever? Do at some point in time, do we stop the machines and allow me to pass naturally? So those are the issues that we're going to hit as we go through the seminar. So first, income taxes. I have this question come up routinely, and it's a very legitimate question. It's just a matter of understanding how things work. If I, or any person, if a parent gives money to a child, let's say a parent gives $25,000 to a child, the question is, does the beneficiary have to pay income tax? And the answer is no, they do not. They don't have to pay income tax on a gift. They don't have to pay income tax on an inheritance. What's going on in either a gift or an inheritance, the way the law looks at it, you're giving principal, not income, to that beneficiary. On the other hand, because it's not income taxable to the beneficiary, we understand it's not income tax deductible to the parent. Tax deductions are primarily going to be limited to certain expenses like real property taxes, mortgage payments, things like that, and gifts to a charity. But your child, even though you may think otherwise sometimes, your child is not a charity, and therefore there's no income tax deduction. Now, income tax does become an issue, however, when we start to talk about estate planning, and we do talk about what's referred to as stepped up tax basis. Here's the general rule. If an individual owns an interest, even an income interest in property, upon their death, the tax basis in that property is increased to the value on the date of death. Now, some of you may not be familiar with tax basis. Tax basis is the way you calculate gain. So for example, if I buy a stock at $10 per share, and then I sell that stock at $20 per share, I am going to pay tax not on the full 20, but only the difference between the $10 that I originally paid and the 20 that I sold it for. That original 10 is basis. So most of the time what happens, we gain basis in our property when we buy it. Now, you may think, well, when I sell a car, do I have to pay tax? Well, no, because if I buy a car for $25,000 and I sell the car for $10,000, my basis in the car was $25,000. I sold it for $10,000, which is less. I had no gain. Now, land works the same way. So if I bought land, and let's just use an example. Let's say that years ago, in fact, let me go to the next slide. Let's use this as an example. Let's say that Dad bought land for $20 per acre. That's his basis. The current value on that land is $400 per acre. Here's how it works. You'll notice that next line. If Dad sells that land, he has a taxable gain of $380 per acre. You see how that works? His basis was 20. He sold it for $380 per acre more than his basis. He's going to pay capital gains tax, which is a lower rate, and he's going to pay that on the 380. He's not going to pay tax on his 20. He doesn't pay tax on the full 400, just the 380. Now, look at those last two lines. That is a situation that arises, and problems can arise if people do not take the time to learn the issues on how basis and gifting works. Now, the example I'm giving down here at the bottom actually occurred. I don't know that the numbers are exactly the same, but it occurred probably must have been about 25 years ago. And what happened is, I had a family call me up in the spring of the year. And what had happened is that the year before, their father unfortunately was dying, I believe, of cancer. And what they did is they were afraid of probate because, everybody says, oh, probate's so terrible. We'll talk about that. But they say, oh, probate's so terrible, we want to avoid it. So what they did is they got Dad to a lawyer. The lawyer made a deed and they gifted the land. He gifted the land to the children, just straight out gifted the land. Now, what the rule is that I told you is that on death, basis steps up to the value on date of death. However, if you make a gift, you gift the tax basis which you have to the recipient of the gift. So what happens when Dad gifts to the children, their basis in this land is now $20 per acre. Now what had happened, as I recall, there was a lot of land. I think it was like a section and a half of land. What happened, the reason I got the call in the spring, is that the children had the land gifted to them from Dad. They turned around, they were all out of state, they sold the land immediately. They were calling me up because they had just talked to the accountant. The accountant said, guess what? Even using my examples, and you'll notice the $400 per acre, obviously that was 20 years ago. The accountant was telling the children, you're going to pay capital gains tax at $380 per acre. Now think about that. Think about that. A section and a half of land. Section and a half of land. Remember, we're talking 640 acres in a section, plus more than that, plus another half section on top, another 320. That was the gain that they were going to have to recognize. Their hope was that by calling, they could somehow undo the gift. And unfortunately, I told them, I don't know of a way to do it. They ended up, I assume, paying the tax. Now, look at the bottom line. If the children, instead of having Dad gift the land, which happened, I think, like a week before his death, if they had simply waited until Dad passed away, they would have gotten the value on date of death, which was what? $400 per acre. What would have occurred is that when they turned around and sold the land, their basis was 400. They sold for 400. Remember what we said? Gain is the difference between the sales price and basis. 400 basis, 400 sales price, they would have paid zero income tax. Now, in some states, some people may say, well, that makes sense because of probate. No, I can tell you, I don't think there's a probate system in the country, I'm sure, and certainly not in North Dakota, that would have made up that difference of $380 per acre for all those acres of land on that income tax. So what's the key? I mean, the key isn't to point to this family and say, oh man, did you goof? I mean, they did, but the more important point is ask the question. An accountant who deals in this, an attorney who deals in this, a financial planner who deals with these kinds of things, that would have been probably a 15-second phone call. And any one of us would have said to that family, do not do it. Do not do it. If we're going to talk about some options that they could have had in the that we have available to us, where they could have gotten the same result. But the most important thing is to ask the questions. People are happy to do that, in all these different professions. A quick question like that, most people are willing to say, sure, happy to ask, happy to ask. Okay, so now the next issue that we deal with, let's talk about that tax. So people are often concerned about inheritance tax. I've actually heard people say, well, I want a will so that we don't have to pay estate tax. First of all, a will is a vehicle that's sometimes used to avoid estate tax. The will itself does not create estate tax. Estate tax is based on the value of your property on the date of your death. But look at where we are. So back when I started practicing law, back in the late 1970s, as I recall, I think the estate tax exemption was something like $40,000. People did pay estate tax, but look what happened. It actually started about 2001. There was a Tax Reform Act in 2001 under President Bush, and what it did raise the estate tax level. I think it started out, it went up to like about $1 million. Okay, but more importantly for us, look where we are. You can see that progression: 2.9, 3.5 million. 2011 goes up to 5 million with a cost of living adjustment increase. So as inflation goes up, that protection kept going up. 2017, it goes up to $5.49 million. Well, you'll notice what happened. Congress passes a law, and they decided to kick the estate tax protection up substantially. You'll see where it is in 2023. Right now, a person, this isn't a married couple, a person living in North Dakota, a resident of North Dakota, has a $12.92 million tax protection. Now, what that means is that during your lifetime, as long as the total amount of gifts that you made, plus the value of whatever is left over in your estate at the time of your death, does not exceed 12.92 million, you will pay no estate tax. Nobody will, I shouldn't see you, your family won't pay estate tax. Now that's per person. Think about it, just roughing it out. Married couple, that's $26 million. Unless your estate's over $26 million at this point, nobody's going to worry about estate tax. Typically, we don't worry about it. Now, look off into the horizon, 2026. Congress does these things. We understand they do things for financial, fiscal reasons. But here's the problem, is in 2026, this law expires. Now, if it does expire, what it does, it goes back to that version, that 2017 version. And the reason I put that plus in there means plus the cost of living increase. Now, the guesstimate, and this isn't my calculation, I am not qualified to make it, but people a whole lot smarter than I am have figured out that if in 2026 the estate tax law is not re-upped, is not reinvigorated, so to speak. In other words, instead of being at by then $13-14 million, Congress decides to bring it back down to its lower levels, we're still going to be looking at probably $6.5 million per person. Now again, for most of us, that's $6.5 million per person, $13 million for a married couple. The vast majority of us are not going to have any type of estate tax issues, and that's a good thing. That's a good thing. Now, you may argue, there could be arguments about, the philosophy of taxing, big estates, but at least what happens is, for those of us who are not in those richer categories, what we find is that even in 2026, if nothing else is done, we're still going to be protected to the tune of about $6.5 million per person. So how does all this fit in? So you'll notice that on this slide, I talked about transfer taxes. So I put it together generically. And then you'll notice in the next line, I said gift and estate tax combined. So what happens is this. is that when we talk about that $12.92 million in 2023, that's a combination. In other words, as I started out, I said, as long as a combination of the gifts that you made during life plus the value of your estate at death does not exceed the $12.92 million, you're fine. So again, you decide to make $3 million of gifting during life. Well, that 12.92 still applies. So your $3 million in gifts is under 12.92. You do need to file a tax return with the government, but you're not paying any tax. At the time of your death, even using those 2023 values, you gave away $3 million. That means you still have $9.92 million in value that you can transfer out of your estate at death and still not pay any tax. Many times what I will hear is discussions and it says, well, but I can give away so much money per year. And it's a little bit of a misunderstanding, and I want to make that clear, is that in 2023, the first $17,000 in gifts each year to any person is excluded. In other words, so when we talk about this 12.92 million, and we talk about dollars being subtracted from that, understand that this first 17,000 doesn't even count. So if I had 10 kids, think about it, I could give $17,000 to each of them, $170,000, and it doesn't even take away from my $12.92 million. Now I want to clear up one issue here that does come back, and that is it's a little bit beyond what we're talking about today, but it does deal with the concern that sometimes people have about nursing care. We all get older. I'm getting older, been doing this for 46 years, so trust me, I'm getting older. You look into the future and you say, well, what if I go into nursing care? Well, many times parents are saying, well, I'm going to start gifting some money. I'm going to gift it. So I want to clear something up. Many people think, well, that $17,000 that is excluded and that I can give away each year, that doesn't count for purposes of nursing home and Medicaid. It does count. It does count. What the $17,000 is, that is an IRS rule. That says that for purposes of the Internal Revenue Service alone, your first $17,000 of gifting does not count. If you give $17,000 away to 3 kids of yours, so what's that, $51,000, and the next year you have a stroke and you end up in nursing care, the government says, well, wait a minute, you gave away $51,000. And for those of you who have some familiarity with the Medicaid system, any gift within 5 years of your application for benefits can disqualify you for a period of time from those benefits. The government says, whoa, wait a minute, you gave away $51,000. You say, well, wait a minute, but it was $17,000 apiece, so it's excluded. The government says that works for IRS, does not work for Medicaid. Does not work for Medicaid. Now, the other thing to remember is that $17,000 simply means that it doesn't count for purposes of transfer tax. That doesn't mean you can only give away $17,000. Sometimes people say, well, but I can only give away $17,000 per year. You can give away as much as you want every year. All that happens is, if you notice that next line, any gift in excess of the annual exclusion reduces the transfer tax exemption. I know I'm using a lot of different terms here, but I think if I use an example, it'll make sense. So mom gifts $57,000 to a child. There are no prior gifts, so we're starting clean. Remember, the first $17,000 doesn't count, but the next $40,000 reduces the transfer tax exemption. So you look at the bottom, what does that mean? Is that, I guess, what I think for some reason I put the 12.8, I think I changed it, should be 12.9, but anyway, we're still in that same category. In fact, actually, I see what I did. Down at the very bottom, that 12,920,000, that's the correct one. And I guess that 12,880,000 is simply my subtraction. I misread my own slide, I apologize. So what it means is the 40,000 that was left over comes off the 12.92 million. You've still got 12.88 million that you can give away in the future. But most importantly, remember, the transfer tax is not going to be an issue. It's not income to the child. It's not a deduction to you. It's not going to generate gift tax or anything. But that $17,000, or in our example, the $57,000 that was given away, if mom ends up next year going into nursing care, that could create a problem because the Medicaid issue is a completely different issue from the Internal Revenue Service. So asset ownership, we said we're going to talk about asset ownership. So the types, you're going to think it's kind of some basic issues, but they become very important. Sole. If I own a piece of property, let's say that, again, let's say I inherited a quarter of land from my parents, and I decided not to put my wife's name on it, or an example, I'm a single person. That solely owned property is going to be subject then to what we call a probate proceeding. It's going to go through the court system. It's not complicated in North Dakota, but that will require the need for a probate process. Now, joint ownership is a different situation because what happens, joint ownership is when two people own the property together. Now, this typically refers to what I would call joint tenancy. So let me give an example. In North Dakota, when my wife Patsy and I purchased our house, it said the deed goes to Casey and Patsy as joint tenants. Now, as long as the deed says that, when I die before Patsy, all Patsy needs to do is go to the courthouse, present a certified copy of my death certificate. They file that at the courthouse. She now owns the house. It's as simple as that. That's joint tenancy. And typically it will say joint tenancy with right of survivorship. Now, these days, I will tell you that 99% of the houses that are purchased with the names joint tenancy with right of survivorship. Now, there's another type of ownership, and it's probably kind of a cousin to joint, but it's a little bit different. Joint tenancy is one thing. The other one is what we call tenancy in common. If that deed had been made out and the deed said to Casey and Patsy, husband and wife, and that's all it said, it didn't say joint tenants, that means that upon my death, my estate owns a 1/2 interest in that house. It doesn't automatically transfer to Patsy, and now there needs to be a probate process to get my 1/2 interest transferred over to Patsy. A difference in the words. It isn't a bad thing. I sometimes see, especially if you bought your house some time ago, maybe if it was done in a private transaction, every once in a while, I see a deed that will come out and it says Casey and Patsy, and the words joint tenancy are not there. If you see that, and if it is your desire in estate planning to solve that issue, it's an easy fix. What happens is you make out a deed. You say Casey and Patsy transfers to Casey and Patsy as joint tenants with right of survivorship, and it's all fixed. Very, very simple process, and that simple deed can save you the cost of a probate proceeding. Beneficiary designations, wonderful, wonderful tool. Bank accounts, life insurance policies, your retirement. You can designate beneficiaries, and that avoids probate. Why? Because if you have an asset and it's got a beneficiary designation, it's not considered a sole asset, because by contract, if I have an investment company and it says Casey owns it, and it says upon my death, I designate my beneficiaries Patsy. If Patsy's deceased before me, then my contingent beneficiaries are the 6 children. Okay, so what we've done there, by the contract with the investment company, we have changed that from truly sole property to beneficially designated property, and that also avoids the probate. You can kind of see what's going on here. In your typical situation, by jointly owning your land, houses, by putting beneficiary designations on your accounts, your investments, your insurance policies, you can do a whole lot to actually avoid the need for a probate. When I have a married couple come in and we do wills for each of them. I will tell the couple that the will on the first death, your goal could be, if that's the way you want it, if you want everything to pass to the survivor, your goal would be to have everything that you could own jointly if it's real property, to beneficially designate everything else so that on the first death, the surviving spouse with the death certificates takes it to the courthouse for the land and the house, takes it to the investment company, the insurance company. Everything is rolled out and there's no need to even look at the will. I typically tell couples, we are making this will primarily for the second death. Now, with a house or land, there's some unique options that we have here that we could use. Again, if the idea is to make the transition as smooth as we can, understanding again that probate isn't terrible in North Dakota, but if you can avoid it, why not? One of them is a life estate. In a life estate, we make a deed out. Patsy and I make a deed, and it says, Patsy and Casey transfer to the 6 children. We transfer our house to the 6 children. But at the end it says, however, Casey and Patsy reserve life estate interest to themselves, continuing until the death of the survivor. So what that means is that the children actually own an interest in that property. If we're going to sell the property, we need their signatures. But the important point is that during our lifetime, we live in the house, we pay the expenses on the house, we control the house, we could move out of the house, we collect the income. The kids really don't have any claim to present possession of that house until we die. But upon our death, by filing a death certificate for Patsy and myself, the land transfers to the 6 children without the need for a probate. The other important item, remember when we talked back about stepped up basis? And I talked about the person who had simply made a deed out a week before death, transferred it to the children ended up paying a good deal of capital gains. Well, I told you that as long as a person continues to hold an interest in the property until death, the beneficiaries end up with stepped up basis. That's what a life estate does. When Patsy and I set up the life estate, if I die first and then Patsy dies, on the date of Patsy's death, the value of that property is the basis in the hands of the children. So think about it. If it's our house, when Patsy dies, they value the house, they turn around and sell it. The value, no doubt, is going to equal the sales price. They don't pay any tax. So if we think back to that gentleman from 25 years ago, if the family, instead of making a straight deed out from dad to the children, had said, Dad makes out a life estate, remainder to the children on death, upon Dad's death, they would have taken a death certificate to the courthouse, they would have gotten stepped up basis, they sold the property for $400 per acre, their basis would have been $400 per acre, no income tax, no capital gains. Now, the other thing that we have in North Dakota, at the very bottom there, is what we call the transfer on death, a very, very neat and usable option. So many times this becomes, let me back up. Many times what happens when people set up living trusts, the most important part in a living trust, when you think about it, often is a house or land, because you can do beneficiary designations on everything else. But if you want the property to transfer down to your children, but remember on the life estate, if you set up the life estate, you can't sell it without the signatures of the children. The transfer on death deed is a little bit different, because there you can say Casey and Patsy transfer to the children, but the words say effective upon death. In other words, the life estate actually transfers an interest in the property of the children now. The transfer on death deed says the transfer only takes effect upon death. So it would take effect upon the second death between Patsy and I. Now, same thing happens. Because we hold an interest in the property, the kids get stepped up basis. But the benefit here is that with the transfer on death deed, if Patsy and I want to sell the property, if we want to change the deed, maybe one of our kids makes us mad, we decide to take him off the deed, we've got the right to do that. We can't do that on a life estate deed because they own an interest in the property. So good options, some good options to think about it. One point to make, the life estate deed, if prepared and delivered, more than 5 years prior to the date that the parents, I'm going to use that example, that the parents apply for Medicaid, that transfer is protected. It's no longer a disqualifying transfer because mom and dad have given up some interest in the house. So that's one we often use in Medicaid planning. On the other hand, because mom and dad can change the transfer on death deed at any time, that does not protect against nursing care. Okay? So it's the transfer on death deed, a great way to deal with, avoid probate, allow easy transfers, but it does nothing in terms of a Medicaid issue. Okay, how about probate? Okay, we've already talked about when does probate arise? Sole ownership. So let's say that Patsy and I have a house jointly owned. Our house, our cars, our vehicles are all jointly owned. All the bank accounts have both our names on it. The investments have both names on it. My retirement account has Patsy designated as the beneficiary. My life insurance has Patsy designated as the beneficiary. But let's say I've got a quarter of land that my parents gave me and it's just in my name. When I die, the house, the cars, the investments, the life insurance, the retirement account, all that transfers to Patsy automatically through a death certificate. The sole ownership in that quarter of land causes the need for a probate. Now remember, avoiding probate, how could I have done it? I could have done it by putting Patsy's name on as joint tenants with right of survivorship. I could have set up a transfer on death deed. As long as I took it out of sole ownership, we could have completely avoided the probate in that situation. Now, it's important, however, it is important to understand that what we want to do, you need to coordinate your ownership with your plans. And you see the big capital letters there on caution, joint ownership. Be careful of this. It can cause a problem. Most of the time it gets fixed, but it can cause an issue. Let's use an example. So let's say that I've got a brother, Jeff. So Jeff and I are the only children of my mother. My mother's now deceased, but let's still use her as an example. So let's say that we set it up this way. Let's say that mom had a house worth $200,000 and she had $200,000 in a bank account. Many times what I hear is people say, well, I'm going to put my child's name on that bank account because they're local. Jeff lives in Colorado, I live in North Dakota. So let's say mom puts my name on that bank account. Mom makes out a will. The will says, I give my property in equal shares to my loving and warm and fuzzy sons, Jeff and Casey. Okay, now think about it. Tell me what happens. Well, mom dies. So the will applies to what? The will applies to the house. So the house was worth $200,000. What happens? Jeff gets 100, I get 100. What about the bank account? Well, joint ownership on that bank account. What's subject to probate? What's subject to the will? Only properties which are solely owned, not beneficially designated, and not jointly owned. You know what happens to that bank account? It goes to me. I am the owner of the $200,000 bank account. Even though mom's plan was that we divide everything equally, I ended up with $300,000. Jeff ended up with $100,000. The issue, of course, is I look at Jeff and I say, well, you know what, Jeff? Mom always did kind of like me. But that doesn't fly real well. That doesn't fly real well. I've seen this happen. Most of the time, the child that has the bank account says, well, mom really did this just for convenience. She really meant it to be shared. So in my case, what happens? Well, I can say I've got the joint account. I picked up a couple $100,000. I make a check out to $100,000 or for $100,000 to Jeff. Does that create an issue? Well, technically it's a gift, isn't it? I gifted $100,000 to Jeff. What do we know about what's going on? Well, what we know is the exemption is $12.92 million. If I give Jeff $100,000, what goes on? My exemption is what? That $100,000, $17,000 of it doesn't count, $83,000 comes off my $12.92 million transfer tax exemption. Really not going to create an issue. Back in the days when the exemption was a lot lower, you know what we used to do? Stop and think. Jeff has 2 boys and he's married. I could make out a $17,000 check to the three, to his wife and to his two kids, and give the balance to Jeff. I'm not doing the math here very well, but that comes out about $68,000 of the 17 that's protected, and I only have to file a gift tax return on, what would it be, $32,000? Because I can gift 17 to one son, 17 to another son, 17 to his wife. I'll give the rest to Jeff, and I've reduced the amount that comes away from my exemption protection. Again, things that maybe you're thinking are too technical, but it goes down to this issue that if you just ask before you do something, just ask somebody, if I do this, does it make sense? Accountants are very good at this. Estate planners, the financial planners are very good at this. They know as well as attorneys do how we can kind of work some of these things around to make it better for people. The business transition, that is actually quite an issue. And the issue that I find on occasion is something like this. And you may have that come up, and we're going to talk about it in more detail a little bit later. But the thing is, remember that if you make out a will that says, I give everything equally to my 4 kids, and you had a child who maybe was involved in a business with you, maybe was farming or ranching with you, or otherwise had an interest. I mean, it could be something as simple as, and I've seen this, you and another child, you end up with, you buy a cabin together, okay? So now the child owns one half of the cabin, you own the other half of the cabin. If you make a will out that says, I give my property to my children in equal shares, guess what? That one child now owns what? A 5/8 interest in the cabin, but now there are 3 other kids, each who own a 1/8 interest. That may not be the way that you wanted it to happen. You could have done something like giving that child the option to buy the others out of the cabin. You could have said, you know what? This child has really worked hard to help me with the cabin. I'm going to give the cabin. It's just a matter of knowing that in a business, the farm, the ranch, the cabin, whatever it might happen to be, you always run the risk that if you don't think about that plan, you could end up creating problems for one of the children. So if there's no will, it's what we call intestacy. Remember when I started out, I said that there's some people who may not need a will. I'm not saying that nobody does, but may not need a will. Let's say that what we've got is we've got a situation where we've got the husband and wife. They have 2 grown children. Children are doing fine, no special requirements, no special needs on the children. So the will is typically going to say what? It's going to say on the first death, husband everything to the wife, wife everything to the husband. It's going to say on the second death, transfer the property to the children. It's typically going to say, however, if one of the children dies before us, if that child has their own children, then they share in the 1/2 interest. That is going to be your typical type of a will. Well, you know what the law says in North Dakota? The law says in what I would call the traditional marriage, the traditional age-old marriage, where what's going on is you got husband and wife, and these 2 children are a product of that marriage. You know what happens if there's no will? Same thing. On the first death, the spouse is entitled to everything. On the second death, the property is going to be divided equally between the 2 children. If one of them dies, the property passes down that line of descent, down to grandchildren, great-grandchildren, wherever. So you can see where in a situation like that, I'll often ask one question. I'll say, did these 2 kids get along? Because if they don't get along, then you probably do need a will to set one of them up as the personal representative, or maybe even to set up a third person, because you don't want the 2 of them fighting over your estate at the time of death. Most of the time, the parents, they get along fine. They're great. They're best of friends. They vacation together. They hunt together. They shop together, whatever it might happen to be. In that case, there's a good example where I indicate, I don't know that I can gain anything for you, because what I would do with a will is what's going to happen in the law. But again, it's done on a case-by-case basis. Do the children get along? Are there any special needs? Any special requirements, I should say? That would throw back to the idea that, husband, wife, 2 sons, one of them lives out in South Carolina, the other one stayed back in North Dakota and helped mom and dad with the farm. Well, maybe you don't want to divide it equally. Maybe then you want to have some special provisions Maybe you need a will in order to set it up so that son who stayed on the farm is protected from what? Well, in intestacy, the son out in North Carolina has a 1/2 interest in that farm and actually can come back and legally could probably force the other son to sell the farm under a type of court proceeding. And we don't want that. We don't want everything torn apart. So many cases it works without a will. Make sure under your circumstances still makes sense. So when are you going to make a will? Again, solely owned property. Or remember, there are ways we can get around it. There are things we can do to try to avoid it. It could be life estate, transfer on death deed, joint tenancy with right of survivorship. You can fix that if you want to. Now, assuming that there is this piece of land and it's not going to be transferred out of my name, what are the formalities to make a will? Well, typically attorneys make wills. I've seen really or reasonably good forms that come off the internet. I don't have any particular problem with them, as long as you realize that in a very complicated process, they probably don't work. In other words, if you got a farm going to a child or a buy-sell arrangement on a business, don't do that off the internet. It's worth it to talk to an attorney. The formalities are that in North Dakota is that once you make that will, you need to sign it. And there are two options. You can either have two witnesses to that signature, two witnesses who should be personally present, should be there to watch you sign, or in North Dakota now it can be notarized. You can have a notarized will. The other option, and I don't recommend it just because it's kind of prone to the possibility of error. If your will is completely handwritten, that's called what we determine or name a holographic will, and that's valid. I don't advise it, but you can do it. What you're going to do in that will, you're going to transfer the property. Remember, if you make a will and says, I transfer all my property under this will, we still go back to the idea that all we're really talking about is your solely owned property. Those joint tenancy properties, beneficiary designations, that joint tenancy between one child and mom, those are still not going to be covered by the will. If you have minor children, always a good idea to have a will. Why? Two things. One is to appoint a guardian for the children, and the other one is to deal with the assets. If you die and you've got life insurance and assets and land and house and all these kinds of things, you don't want to give that to a 15-year-old child. So typically what happens in a will with minor children, we're going to set up a trust. And the trust is going to take care of those children until they reach a certain age. And we see all kinds of things there. Now, when I started practicing law way back when, it was very common that would say the trust will stay in place until the child reaches the age of 22, maybe 21. And we still do something like that. But it depends on the child. For most children, I think if we're honest with ourselves, we understand that they're not going to be mature enough at the age of 18 or 19 to deal with property, especially if you're talking about a retirement account, an IRA account, the value of a house. I don't know about you. I tell you what, if my parents had given me a couple $100,000 when I was 18 years old, I'm afraid I would have been very tempted to run off to Colorado and ski the money away. And those are the kinds of things we try to protect against. More often than not, we will actually do what I call incremental distributions now. We might say that if any child of mine is under the age of 28 years at the time of death, the property is going to be held in trust. While it's in the trust, the trustee can use the money for the education, the health, and the support of the child. And when the child reaches 22 years, whatever value trust is left at that point in time, the child can get, say, 10%, 15% of it. And then they say, and when the child reaches 25, give them, say, 50% of whatever's left over. And when they're 28, give them the balance. So you can see what's going on is it's, in a sense, it's this ability to allow the child to become accustomed to the fact that there are assets coming in. Now, there's no limit to how you do this. Very often I'll see up to age 30. I've seen age 40. I've seen people who set it up so that the child doesn't get anything until they reach 55. I'm sorry, not 25, 55 years of age. And then what they do is they incrementally pay it out. Basically, it becomes like a retirement supplement. Neat issue. Special issues, we talked about those to a certain extent because what's going to happen is if you've got that farm, you've got that land, maybe you've got a special car, maybe you refurbished a vehicle and you want that to go to somebody. If you want special issues, then you're going to need a will to take care of them, and we can put those into your will format. Protective trusts. We talked a little bit already about the minor children, the fact that we don't want the children to have that money, especially when they're under 18. My advice is still you stagger it out over a period of time, especially if it's a fairly substantial amount of money. And understanding, there are a lot of estates out there, just the way the value of property has gone up in recent years, where there's substantial value in that estate that you may not want to give to an 18-year-old young person. If there's a child with a disability, maybe there's a family member with a disability, we can set up some protective trusts. We refer to them typically as supplemental trusts. In the case of a child or a person with a disability, typically what we're doing is we're setting up a supplemental trust, the purpose of which is to allow some added enjoyment for that person with the disability, but to set up the trust and allow distributions in a way that will not disqualify that individual from their benefits, from their Medicaid, from their supplemental security income if they're getting it. So you're setting it up in a way that it helps them, but it doesn't disqualify them from benefits. Your trust is going to provide for the use of assets and the timing of distribution. We talked about that typically when we're dealing with minor children. For example, use of assets. In the trust that we typically use in this office, anytime as long as the trust is there, the trustee can use it for education. And we broadly define education. Could be on-the-job training, vocational training. We're not talking about just going to college. And you even define, you have the ability, I should say, to define what is paid when they go to these to training, to vocational training, to college. Sometimes they say, well, help pay for room and board, can help pay for this, can help pay for that. You can put limits. Sometimes they say you can pay for education, but the tuition to be paid can be no more than, for example, the tuition currently then payable at the University of North Dakota. Why do people do that? Well, maybe they don't want the child to go off and spend the money for tuition at Stanford, which might be $80,000. I have no idea. But so you always can control how that trust is going to be used. Who is the trustee? There are a lot of very, very qualified professional trustees around. Almost every bank has a trust department these days, and that's fine. I will tell you that in most instances in this modern era, I will have somebody from the family watch over that property. There has to be a trusted person, watches over the family. So for example, many times in a family trust, if there are two kids, the trust is only going to come into place, remember, if one of the children dies. I will very often have the other child serve as the trustee. Now you may say, well, what if they don't know everything that's going on? The thing is these days, there are accountants, attorneys, and financial planners who can be there ready, willing, and able to help that trustee to make the correct types of decisions. I got just a quick reference to tax trusts. Some of you may in the back, maybe you've encountered a tax trust dealing with your parents. Back in the days when that estate tax exemption was lower, we often used a tax trust, which would divert some money over into a trust during the lifetime of the surviving spouse. And I only bring it up because you may say, well, gosh, I remember mom and dad had something like that. And when dad died, some of the property automatically went into a trust for mom. I only bring it up because it's not used as often under the new tax, because at $12.92 million, it's very, very rare that we're concerned about using trusts to protect against estate tax. So what about the revocable trust? What's the deal with those? Very, very popular, probably back in the 60s, not in the 70s and the 80s. And typically it was touted as a way to avoid probate. What happens in a revocable trust, you actually take the title to the house, the title to the investment account, the title to the cars, and you transfer it all into the name of the trust. Typically, In a revocable trust, you are going to be the manager. You're going to be the trustee. You're operating your own trust. The purpose for it really is to avoid probate. Now, I already told you, I've got clients with properties in certain states. I will use a trust for those properties. In the state of North Dakota, my typical advice is to go with the will because the probate in North Dakota is so simple. It is so simple. Good question to ask your advisor, whether it's the accountant, financial planner, or attorney. What do? I have a will. I have a will because I know that probate is so simple. I'm not worried about doing a revocable living trust. That doesn't mean that we don't do them. That doesn't mean that we don't do them. And if you do it, you just need to make sure you put all the assets into that trust to take care of it. Income tax, revocable trust doesn't cut. You still pay all your taxes through your 1040. Nothing is going to change. Estate taxes. Understand that what's going on is that the revocable living trust does nothing to change the rules or the protection on estate tax. It's kind of like that transfer on death deed we talked about. It's revocable and therefore everything stays the same. You're going to pay the same estate tax whether you have a revocable trust or whether everything is in your name. Now, one good option for a revocable trust is in the event of disability. You can use the trust to have a successor trustee to manage the properties that you've put into the trust. That does make sense. We're going to talk in about 2 minutes of another option here that is a counterpart to using the living trust for disability. And notice down at the bottom, again, as with the transfer on death deed, because there's no protection from nursing home, that means that because you can revoke it and take all the property back into your name, it doesn't protect from nursing home cost. Irrevocable trusts, I just put it up there, you may run into them. Sometimes in the past we did life insurance trusts. You may find your parents set something like that up. We do it very rarely these days because it was a device to avoid estate tax. Minerals, we see a lot of irrevocable trusts on minerals. It's a way for mom and dad to set up a trust, keep the income for them, pass the income down to the children, income down to the grandchildren. Usually, in my opinion, the purpose for that trust is that instead of having each child and grandchild negotiate separately with the oil company, the oil production company, now you have a trustee who can do the negotiation for everybody. It's a good option. The business, I think we've probably already talked to some extent about this. And again, family business, the farm, the ranch, the family, the family retail business, whatever it might happen to be. And the problem is, as I've touched on, that stay in the business child. I just made that up, but I think it tells what we're talking about. That child who worked in the business and stayed there and worked with mom and dad. In the standard will, if it says I give all my property to my children in equal shares, you, for lack of a better term, you just threw that child under the bus. Because now, unless something was set up, that child's got to go and negotiate with that child's siblings to try to find a way to continue that business on. And if one of the children says, I want my money now, you got big problems. So the issue becomes fair division, and sometimes other things happen. Sometimes you can say, well, we'll give the business to the child, we'll use other assets, and we'll give those to the other children. We'll use life insurance as an example. The life insurance policies will go to these other two kids, and the child who stayed in the business will get the business. Sometimes understand, especially when we get to the values that we have in farms and ranches these days, sometimes you cannot do a fully fair division, and then you need to make a decision. Is it important enough to protect that child who's stayed on the farm with us, even though the other children get less money? Or another option is, are we going to have the child on the farm, under the provisions of the will, make payments to the other two children, scheduled payments? In other words, you're protecting the child because you're giving that child the opportunity to make the payments over time to equalize the division. And the bottom down there, that nobody wants the business issue, it's just a matter you put in the will. If nobody wants it, you say, you direct the personal representative to sell the business and divide the assets out. Now, last two items, the power of attorney and the healthcare directive. Remember I said that there's an option to having a living trust hold all your property to allow management in the event of disability. The other option is what we call a durable power of attorney. That is effective during your lifetime. It gives a lot of powers to people. When I started practicing law, the power of attorney was about 3/4 of a page long. It said, I give to my agent the right to do anything I could do. Now the powers of attorney that you're going to see, if they're made by an attorney or even if they come off the internet, they're generally going to be 5, 6, 7 pages long. And I'm going to tell you, we always like to blame the attorneys for this stuff, but usually what it is, the government agencies, the investment companies, the banks, they prefer to have specific reference to them in the power of attorney, and that's what made it longer. Remember, what it does, it gives to another person the authority to sign your name during your lifetime. It ends at death. So the power of attorney has no right to distribute your estate after death, because at the instant of death, that power of attorney disappears. Now, the words of durability, there's your most important. The power of attorney must say, the authority, and I'm paraphrasing, but this power of attorney continues even in the event of my future disability. Those are the words that allow that power of attorney, that when you become disabled, which is when you typically want this to have coverage, that is when you want it. In North Dakota, as in almost every state, if you don't have those words in there, under the old law from a century ago, if you became disabled, it acted in the same way as death. Both death and disability terminated the power of attorney. Now, death still does it, but as long as you've got those words in there that say, continues even in spite of my disability, now that power of attorney continues on and your agent can make decisions for you. It typically avoids a guardianship. You don't want to get into a guardianship. They're expensive, they're time consuming. You need to get a doctor involved, a social worker involved. There needs to be an attorney not only for the family member wanting the guardianship, but there also needs to be an attorney appointed for mom for whom the guardianship is going to be established. It gets pricey. It gets pricey. You can do some gifts. Some states, you may have seen, have a statutory format. We don't. In North Dakota, if you see a power of attorney, I can just about promise you that attorney created that form. I know in our office we did. If I was tell people, if you see a form out there that looks like mine, somebody copied mine, which is fine. I don't care. But we in North Dakota do it individually rather than by statutory format. So again, power of attorney gives somebody the authority to take and make decisions on your behalf during your lifetime. And the same holds true with the healthcare directive. What that does in simple forms, it says this. Now remember, that power of attorney can be effective during your lifetime, even when you are competent. If somebody's got your power of attorney, you can say, hey, take that power of attorney down to the bank, show them that you're authorized to sign my name, and I want you to deal with those transactions down at the bank because I'm going to be out of town. Healthcare directive's different. The healthcare directive says that this only comes into effect if you cannot communicate with your doctor. That's the only time. So what the healthcare directive basically says is, I designate, let's say in my case, I designate my wife, Patsy, to make healthcare decisions for me when I cannot. Now there again, the form for the healthcare directive, unlike the power of attorney, is actually set out in statute. There's an example in statute. And I think most attorneys probably work off that example. I mean, there are others, I see hospitals often have them. They're not necessarily the same as the state legislative form, but they're still functional, they still work. It's going to talk about, your healthcare agent, if you can't make decisions, can deal with your treatment decisions, decide who's going to be your provider. We put into ours what I call the old living will language. It says, if I am dying, what's going to happen? And I can say one of the options is, if I'm dying, do I want to get what we call the application of nutrition? Typically would be a feeding tube. And in the form we use, there are 4 options. It says I want it, I don't want it is another option. A middle option is I want it until it's no longer working. And a 4th option says I'm not going to make a decision, which means what? That means your agent is going to make that decision when you can't. And finally, permanent unconsciousness. If in fact I am permanently unconscious, we have in our form a provision that says if the doctors say I am no longer, there's no reasonable chance that I'm ever going to recover from this, you as my agent have the authority to let me go. Now, you make that decision. Some may not want that. Some may say, nope, if there's any chance, you keep the machines going, and that's fine, but it gives you that option. The important thing, remember, make a plan. Think about what you're going to do and make a plan.